we can now start the presentation of this book. The book and the presentation of the author, Michael. The book is titled MJBQC, which, by the way, I know that is an outdated title for reasons obviously beyond the control of Michael, because a second edition would have to be titled MJBKC, as he is now. Who is Michael Beloff? Actually, we have a book explaining who is Michael, so I cannot in few words summarize his life, his studies, and his accomplishments. Michael is a sort of, using a reference to track and fields, which is Michael's favorite sport, I can say without any restraint, because I'm sure that this is the truth, is a sort of decathlete, because he was counsel before several jurisdictions in England and abroad, including top jurisdictions such as the European Court of Justice, the Court of Justice of the European Union, as it is now, or European Court of Human Rights. He was a judge, actually, not strictly speaking in England, but in Jersey and Guernsey, where he became also an appeals judge at a certain point, I understand. He has been an arbitrator, both in commercial cases and in sports law cases, which is where Massimo and I had the chance to meet Michael at the Court of Arbitration for Sport. He has been a member, still is a member of disciplinary bodies across the board in different sports. He was called to the bar in England in 1967, I understand, if I correctly noted that. He became a QC, as he then was, in 1981. And he had also an academic role. He was the president of the Trinity College in Oxford for 10 years between 1996 and 2006. In that capacity, he had also the opportunity to meet several people. We have also some photographs in the book, because as a good common law lawyer and counsel, Michael prefers direct evidence to hearsay. So the direct evidence is in the book by way of the photographs. There are photographs with at a certain anniversary of a college where he studied with law lords and members of the US Supreme Court. There is a photograph with Bill Clinton, where there was the 26th president of Trinity, which was founded in 1550, was meeting with the 42nd president of the United States, which was only created in 1776, so more than 200 years after Trinity. He was named to be the father of sports law, chiefly in England. I do not know whether he likes this indication, because at least this question begs another question: who is the mother of sport law in that respect? But he was certainly one of the first and the leading sport law lawyer and arbitrator in that case. There is, I would say, a coincidence of profession and passion in this indication, because to be involved in this case, kind of cases, you need a lot of passion, and this is why you probably do that, and Michael did that. So we have many, probably we have a wide audience, we have many people, we shall have some questions, some discussions, but the first question, Michael, is why did you write this book? Because actually this is the first, is a very difficult, well the question is easy, but maybe the answer is difficult, because this is also a question that is opening the prologue to the book. Maybe after reading we can give an answer, but what was your intention, and what is the purpose that you sought?
There are two answers, one of which is somewhat shameful, the answer being pure vanity. The other, which I hope is more respectable, is that I actually wanted to do something that drew a line under my career. And my thinking was, if I wrote a book of this kind, I wouldn't want to do anything after that was really interesting, because I would always be wondering, oh, I wish I'd put that in a chapter and so on. So those were the two reasons. But I suppose the third one was pleasure. I enjoy writing, and this was a good opportunity to exploit that enjoyment for myself, if not necessarily for my readers.
Okay, well, but because people who know you, well, I learned a lot. I wish I had read this book some years ago, so that we could have discussed or verified other points. Because the book certainly shows the changes to the profession over the years, and also in the different fields where you were involved, and I also find it interesting to read your background, your education, about your family. And as I was mentioning a few minutes ago, this is a small anecdote from my family, because I had this book on my table some weeks ago, and my son, who was studying political sciences, had to write some time ago an essay about Churchill and Europe. And my son said, but there is a famous historian named Beloff that I had to read about. And then I discovered that this was Max Beloff, the Michael's father. And actually, Michael studied also history at a certain point in his life. But reading about your book, I also noted that one of the first sports you were introduced to was boxing. Is boxing an important part of the education of a good lawyer?
I can see there are various arguments in relation to that. I suppose a certain degree of pugnacity is a quality that advocates should enjoy, but perhaps more importantly, if one's appearing in front of a somewhat truculent arbitral panel or judicial body, self-defense is also an admirable quality. It's a very ingenious question, which I would not have thought of myself. I think the answer is it's probably more peripheral than central to one's career as a lawyer. Boxing, that is.
Yes, yes. No, this is very interesting. Then we read about I read about your experiences at the bar, but going to sports law, which is the part that is also interesting for foreign lawyers. Maybe we can go to Massimo to say something in this respect.
Okay, thank you, Luigi. And it's a privilege being here, presenting Michael and discussing with him. And in particular, I'm interested in two chapters of the book. One is entitled My Sporting Life, and it speaks about Michael's experience in sports law, and in sports arbitration in particular. And another chapter is chapter 14, is called The Art of Advocacy, and I liked very much that chapter. So we will touch on both, try to touch on, to deal with both chapters. With regard to sport, Luigi mentioned that Michael is known as the father, and sometimes he is known as the godfather, actually, of sports law in England, so that's how we framed him for this presentation here. You know, it was an offer he could not refuse, in fact. I met Michael as a CAS arbitrator when still it was possible to be an advocate. Michael was already a CAS arbitrator himself, but he could be an arbitrator. He could be an advocate in front of the CAS. It was a very interesting case, the Enoch case, which was perhaps the first landmark case, really, of the CAS. I had the honor of chairing that panel. And Michael, you mentioned that at page 184, you mentioned that case, which, by the way, the hearing was in days which are quite sad for you, because your father had just passed. I remember it was March 1999. But, you know, your performance was very good, although the case went in the other direction. The other side won that case. But that case gave the opportunity to the panel, and in particular, as chairman, I wrote the draft of the award, and I wrote those words to say something about the emerging lex sportiva. At the time was really emerging, and you mentioned that in your book. What do you think? What is really lex sportiva in your opinion, and why is it or is it not important?
I've become very wedded to it, and in my days as an arbitrator, if there was any excuse for referring to the lex sportiva, I would try to persuade the other members of the panel, whether I was chairing it or not, to make some reference to it. Because I think it is important for the development of sports law to recognize that there is some facet that is really truly sport specific. Now, the extent to which the concept of the lex sportiva can actually be used, as it sometimes has sought to be used, to override express provisions of the rules of a governing body or the procedures that are applicable to the particular sports governing body, is still a moot point. But actually, the panel that laid down in the Enoch case the concept of the lex sportiva did regard it as being of that kind, capable of, no doubt in exceptional circumstances, overriding the written law, and not just, as the analogy drawn with the lex mercatoria, filling in some kind of gap that is otherwise present in the complexity of a commercial code or statute. So I think, Massimo, I agree with you. I think in many ways this is as important a case as CAS has ever decided, because not merely was there the reference to lex sportiva, but the panel ranged across European community or union law, as it was known, the human rights as well as Swiss law. So almost everything that one could think of as an aspect of a law that might apply to future cases was dealt with there. And I was very proud to have been a part of it, even if, as alas, sometimes happens on the losing side.
No, but by the way, it was on the losing side, but actually you won essentially on all the arguments, except final, because, you know, if you remember, for those who do not know the case, it was a case about a company, a British, actually listed on the stock exchange company, ENIC, owning several clubs around Europe, and UEFA, the European Confederation for Football, enacted a rule forbidding teams owned by the same owner to participate in the same competition. That was the essence of the case. And UEFA tried to dismiss, saying, well, competition law has nothing to do with that. We have done nothing wrong. Essentially, UEFA did not phrase it in that way, but it was asking for it was like a motion for summary judgment. An American lawyer would call it a motion for summary judgment to dismiss the case right away. We did not do that. We follow exactly your arguments. We went all the way, just until the last moment, when finally the analysis of competition law said that it was not anti-competitive, actually, the rule itself. It has some justification. And by the way, the European Commission later on confirmed the view of the CAS. So it was, but I must say that we followed all your arguments. So in a way, you won the battle, but you lost the war in a way. But talking about Lex Sportiva, one case you mentioned was very interesting. One case, you wrote the award, and by the way, I can mention here that many of the awards written by Michael have become really fundamental in the jurisprudence of the CAS. So I call him, not coincidentally, I call Michael Maestro, and he knows that. And by the way, I noticed, talking about that, I noticed that in a footnote, you compare yourself to Giotto in a way, and in terms of sports law, and that, you know, innovating compared to Cimabue was the, you know, the old painter not having the perspective yet. But I call Michael Maestro for this reason, because he wrote really very important awards in the history of the Court of Arbitration for Sport. And one of the cases he wrote the opinion for was the case about a Korean athlete and an American athlete in Athens, at the Olympic Games in Athens. And it's an important case, important award, because there you had a chance to write and explain really what the field of play doctrine is. And can you explain a bit what is the field of play doctrine and what really was the case about? It was an interesting case.
So it was a very interesting case. It arose out of the Athens Olympics, where I was on the ad hoc panel. It couldn't actually be decided within the confines of the games because it was decided right at the end. And putting it very shortly, it was the men's all-round gymnastics. And those who follow gymnastics know there are effectively 5 separate events. And in the penultimate event, the Korean competitor was misjudged. It was an error not in the evaluation of his performance, but one's performance is judged on 2 bases in gymnastics. One, its difficulty, which is an objective criterion, and then within the confines of that difficulty, how well you performed. And the judges had wrongly ascribed, and this was common ground, the degree of difficulty. And had they got it right, then the question was, well, would the Korean not in the end have won the gold medal at the expense of the American, who was in fact awarded it? And originally, when we first saw the case, we thought, well, it's obvious there was a mistake there, an admitted mistake. If the mistake had been corrected, the Korean would have got more points and he would have been elevated to the podium in the gold medal position. But then we stopped to think, well, is that really so? This was the penultimate event. How do we know how he would have behaved if he'd gone into the final event in the lead? He might have, as they say, choked. He might have got impetus. And so we realized it wasn't as easy as it looked at first blush. And in the end, we took the view that this did fall within the realm of the field of play. This was an issue in which the internal mechanism for resolution of an issue of that kind had to be left within the confines of the sport itself. And there were all sorts of reasons for that. One has to try to uphold the officials. One doesn't know what the result would be if one started to, as it were, look at it from the outside. And so we laid down here, I think emphatically, the field of play, which does immunize decisions which are taken on the pitch, in the arena, in the pool, from review by an outside body, even if there are errors in the form of judging. And we have to say that I think we said that finality is important here, and rough justice in that sense is all that the sport should tolerate.
Yes, I think that's very. I always quote whenever I lecture or I speak about sports law or sports arbitration. I always quote that case because it's very important, because you didn't mention this detail, but in that case, the International Federation for Gymnastics even officially addressed the US athlete, asking him to return the medal in favor, as a spontaneous gesture, in favor of the Korean athlete. The US athlete said, forget about it. And then the case went before the Court of Arbitration for Sport, where you chaired the panel. I think it's very important, because if you refrain from reviewing a field of play decision, even in a case where the referee or the umpire, whatever is called in gymnastics, has admitted the error, the International Federation has admitted the error and even asked the athletes to spontaneously change the result. And if you immunize that field of play decision, even in this situation, I think it is safe to say that unless, and you put that in the word, unless there is bad faith, essentially, so corruption or situations of that kind, whatever happens on the pitch stays in the pitch. It's like Vegas in some movies.
And in that, in the field of play rule is in fact an important element of a lex sportiva. It's something that is peculiar to sport, but I think essential to sport.
Yes, and an important point you say is not reviewable. It's not that there is no jurisdiction, or it's simply not. It's kind of a self-restraint of the arbitrators vis-a-vis the judges that are on the pitch for several reasons. Of course, competence in the sense of knowing well the sport, being on the place, and also you quote, by the way, in that award you wrote, you quote a previous award written by Peter Lever, so a colleague of yours, another QC, a KC now barrister, who wrote something similar. And the fact that mistakes sometimes are made by referees as they're made by players, and we have to accept that. It's an inevitable fact of life. Another case I think it's interesting for our participants to mention, where you were involved, is the case about the Peruvian football player Paulo Guerrero. We were together in that panel, and I have the honor of sharing with you the definition given to the arbitrators by the Peruvian media, which is, if I may mention that, I don't know, it's not very polite, but it's too funny to be with you in that definition. We were defined as bastards of shit by some Peruvian media. And I remember also by other Peruvian media, we are defined as the executioners of Paulo. And our pictures, Michael's, mine, and Jeff Benz, a US arbitrator who was the third arbitrator, were all in the first pages in the primetime news on TV with our picture there. as with the qualification I just gave before. What do you remember of that case, Michael? About apart from the fact that we were not very welcome in Peru, probably.
I'm going to say I don't plan to visit Peru in the near future or ever. Of course, I remember it very well because it became virtually a of national importance. I mean, Peru don't always get to the finals of the Football World Cup. He was their key player. I think he was their captain. The president of Peru, not just the president of the Peruvian Football Association, pronounced upon this. And the interesting feature is, and one understood why, they went to the Swiss Federal Tribunal and they got an interim injunction which would allow him actually to play in the final, irrespective of what the ruling would finally be as to the correctness or otherwise of our decision. He played. Peru didn't get any points at all, were eliminated very early from the final. And then when our substantive decision went to the Swiss Federal Tribunal, it was actually upheld. So in one sense, honour was done or justice was done all round. But it was, I mean, sport and politics.
We should mention it was a doping case, actually. A cocaine doping case.
It's quite interesting again, because some arbitrators, let me put it this way, are regarded as being on the whole sympathetic to the governing bodies, others more sympathetic to the athlete. I think I'm regarded, fairly or unfairly, as being in the former category, not that anyone suggested there's any kind of bad faith or lack of justification for my opinion. But in that case, we accepted, the majority, and in fact all of us accepted, that this was an accidental doping because he drank a tea made of some local component that did obtain cocaine. So actually it was quite a sympathetic judgment, but although of course in that sense it was accidental, nonetheless it was a violation, and that's why we held that he should have been disqualified for a while. And as I say, he got the stay, they played, didn't succeed, but ultimately our decision was upheld, which is quite satisfactory.
Michael, in your book, you clearly state that you had essentially a love affair with the Olympic Games. Starting from the very first Olympic Games, you were in Rome, 1960. And as I'm speaking from Rome and the Italian Association for Arbitration, as its headquarters in Rome, I was very happy of reading that. And how many Olympic Games were you involved in? As a spectator or as a professional arbitrator?
I think I've attended, 9 Olympic Games, 5 as an arbitrator, the others obviously as a spectator, and in the Rome case as a very young student between school and university.
Well, and apart from spilling some wine on Andrew Lloyd Webber, I think that happened in Barcelona.
And indeed to our Prime Minister in Barcelona.
Well, apart from this, what do you remember of those Olympic Games that really stand up to your memory and really
the Rome ones or generally? Are you asking the question?
In general, no, all Olympic Games.
Yeah, I mean, I was going to the Rome one was so interesting. The whole culture of sport has changed in Rome. It was very free and easy. You could walk anywhere. There was no security. And it was a quite different atmosphere from the highly politicized and very security-conscious games of today, which all you and Luigi and I all know from our own experience as being on ad hoc panels. I think the best games I ever attended were probably Sydney. They were absolutely superb, and we discovered, one of the things I discovered, you could actually go by boat to the main stadium along the river there, and Sydney's a marvellous city, and it was very well attended games. So, I mean, they've all been memorable. I mean, there were no Olympic Games I've attended where I've been disappointed, certainly in the quality of the competition. I have different views about the merits of the particular cities. But yes, the Olympics have been part of my life.
Luigi?
I remember in Beijing 2008, we were together, There was always a problem of discussing the organization of transport with the transport desk of the hotel. They were very kind, but their command of English was not to the level of their kindness. So and they developed a sort of attraction to Michael. So when there was something to talk about, they were calling Michael. And so in the stadium, when a final was about to start, there was always the transport desk calling him on the Olympic phone, and this was really a point that I will always remember. We were in the same hotel as the Argentinian football team.
Yes.
And
Messi was there. Oh, and all sorts of people there. Carl Lewis. Do you remember the famous Romanian gymnast Nadia Comaneci? I mean, our hotel was full of people like that. It's another feature of the games that's been so interesting.
Yes, absolutely. But going to, I don't know whether Massimo wants to go back, but because we have an audience of Italian lawyers, but not only. We have also other colleagues. You had the experience at CAS of having counsel appearing from different jurisdictions. What would you comment about the different attitudes? Because you're used to your jurisdiction, to the presentation of cases before English courts by colleagues sharing with you the education, the experience, and the forma mentis, or the way to present the cases. What would you say about the different lawyers of the different jurisdictions?
Well, let me make a preliminary remark. I mean, as an arbitrator, I was very impressed by the fact that almost always the panel took the same view about the justice of the result that was reached, irrespective of the jurisdiction from which they came or the legal culture in which they were brought up. There are, of course, very few cases, and dissents are not acknowledged as such, as you all know, they're majority decisions, and therefore one can work out from that someone must have dissented. In terms of presentation, I agree, Luigi. I mean, there is a very significant difference between persons from common law jurisdictions and persons from civilian jurisdictions. One of them is that civilian jurisdictions pay more attention to written documentation than do those from common law jurisdictions. And the obverse of that particular coin is that common law advocates, common law judges, pay more attention to demeanor, the way witnesses present themselves, than again civilian judges do. Actually, and it's not just as a result of the Court of Arbitration for Sport, our approach is becoming more closely aligned to the civilian approach than it was previously, partly because of our temporary membership of the European community, but partly, again, because of the experience of international bodies such as CAS, to which we all belong. I still think, and I think this is not, as it were, a patriotic or even chauvinist view, I still think, on the whole, the advocates who appear before us from common law jurisdictions are better at presenting certainly oral arguments for the reasons that I've given. But I mean, that's a view that my colleagues on CAS have very frequently expressed. And actually, when I've spoken to judges who are familiar with the European Court of Human Rights, they tend to take the same view. But of course, these days, it's not just oral advocacy that wins cases. Written advocacy is very important, and at the end of the day, merits will out.
But what is your view as to intervening into the presentations which is something that I see sometimes to surprise counsel, because I understand this is a feature common to your jurisdiction more. When the judge is not interested in something, the judge would say that. I mean, here probably the judge would sit silent and then just listen and then not to pay attention thereafter. What is your view on this point?
Obviously, as I say, you've epitomized the common law tradition. I actually think that it actually assists advocates to have some notion of what the judge is thinking at the time, in order that they should be able to address something that may be troubling the judge or the arbitrator. I mean, the downside, it might be said, is when you're disrupting the flow of the argument. And I once sat, I remember in early days, sitting with a distinguished CAS arbitrator. When I asked a question, I was just one of the members of the panel there. He actually turned to me and said, "I don't think you ought to be intervening at all." And I found that actually very surprising and not very helpful, because he was the chair. I obeyed what his direction was. But I think that, I mean, advocates, there is no point allowing an advocate to pursue a path which you find unpersuasive and not giving some indication, because in many senses his time is wasted unless, and if you've already made your mind up, say, I don't think very much at this point, why let the advocate pursue it? Why not give him the chance of saying, well, I don't think very much of this, this is my concern, and then he can address the concern. So in the end, I think justice is better served in that kind of procedure.
But the same also applies to the examination of witnesses, because my feeling is from time to time that there are questions that are obvious to a witness that are not asked by counsel. So my consideration is whether I should ask as an arbitrator that question or not, because maybe there is a reason why counsel is not asking that question. What is your view? Is your attitude depending on the level of the counsel, for instance, that you realize that is not
That's a very, if I may say so with respect, very intelligent perception. I mean, obviously, if you've got someone of huge experience and they don't ask an obvious question, then one would tend to assume they don't want the matter agitated and they're entitled to take that point of view. But on the whole, my experience is that actually most of the counsel are not very familiar with cross-examination at all. I mean, I know that, I mean, basically, in the English common law system, if you consider that a witness or a point is being developed that has been simply misunderstood in some way, or that a point is being made that ought to be challenged by, as it were, the other side, and it hasn't been challenged, then something's missing. Cross-examination in England, you are basically meant to put your case, not every detail of your client's case, but enough so that the witness who's giving evidence to a contrary effect knows what's going to be argued. I find the cross-examination in CAS, obviously, sometimes one says, well, I don't understand why this is being asked at all, and equally I don't understand why something else is not being asked. And I think, again, Luigi and Massimo, I think at the end of the day, as an arbitrator, you have to try to say, well, is justice going to be better served, as I can see it, by intervening, or by putting a question which ought to be asked, or by restraining one's curiosity and so on. I mean, it's a matter of judgment from case to case. But on the whole, I don't think cross-examination is done very well in front of us. Okay. I don't know whether you two agree.
Luigi, I have a question. Michael, speaking about the objective of serving justice, you mentioned in your book about one only, you have been a CAS arbitrator since 1996, and you mentioned just one case in which you had one arbitrator who behaved partially, and a Chinese arbitrator was then removed from the list, in fact. Do you think this, and I can confirm, in fact, that I always felt a lot of independence and impartiality in CAS arbitration on the part of the arbitrators. What do you think in this connection? What do you think of the so-called closed list, which is in fact not closed because arbitrators are added quite often? So I'd like to call it more as a mandatory list in which you have to choose the arbitrators rather than a closed list. But what is your take on that? What do you think? Is that helping in independence or impartiality, or is to be criticized, as many people sometimes do, because parties do not have the freedom to choose the arbitrators they'd like to choose?
Yes, I mean, my own view, especially given the extraordinary expansion of the CAS list over the quarter of a century I've been a member, it's very difficult to think that there aren't going to be sufficient freedom to choose from that list, which would otherwise be, as it were, infinite. Indeed, there'd be no list at all. So, and my experience, and I've sat with many arbitrators, obviously by no means all of them, very, very rarely have I detected anything that I could think of being somewhat suspect in terms of, are they really acting here impartially and not in a partisan way? I mean, you mentioned one Chinese case. I remember another case. I didn't do more than particularize the nationality. Again, it was a Russian case where it seemed to me to be quite clear that the advocate was the arbitrator was acting as an advocate for the Russian side. And as you know, as commercial arbitrators, especially international commercial arbitrators, it's a not uncommon feature, actually, that it's almost expected of the arbitrator who's been appointed, let's say, by the claimant, to take the claimant's side, at any rate, in the way in which it's conducted the hearing, which is distinct perhaps from the result that's being reached. But I find the objection you refer to, Massimo, as being more theoretical than practical. If there were only 25 arbitrators, I'd have some sympathy. Now, when there are 600 and growing, I have no sympathy. There's enough choice available.
Luigi, if you have...
Maybe we can turn to the audience to
yes.
see whether I see that there are some well-known colleagues online. Maybe if they want to add something from their experience in dealing with Michael.
Perhaps you could rephrase that.
I might add, before we give the floor to the participant, I might add that one incredible experience, very nice experience, and whoever sat with Michael knows that, is reading Michael's emails, because sometimes they're written like James Joyce, you know, in the Dubliners, you know, like a flow of consciousness, a stream of consciousness, where you hardly distinguish the words and the you know, and the commas or peels. But apart from that, I must say that it's a wonderful experience to be in a panel with Michael, and say that we can solicit questions from the floor.
Can I just make one plea in mitigation? My plea in mitigation is I think that my mind is parts of my fingers there. So the reason is that I'm putting, as it were, the words or something in the wrong order. And secondly, which is not much mitigation, is I tend not to proofread. And thirdly, I haven't yet mastered how to work out with sort of spell check and corrective mechanisms. But there it is. It's a very fair criticism. You and Luigi have tolerated over many years. Yes.
Yeah,
Any questions from the floor?
We can appear as witnesses to confirm that it was always not only to dine at the Chateau, but also to sit with Michael. So is Stefano.
Thank you very much, Michael. I love to be the icebreaker and start with questions, but I have one question. Actually, there are two questions, two folds. The first one and the second one comes if you do agree with the first one. My first question is the following. I am involved in sports, not arbitration, but more disciplinary process, and since many years. And in two sports in one sport that is quite popular in this country, at least, that is football. My question is the following: being involved for many years in sports, not arbitration again, in sports law, what I see is that there is no, I would say, improvement. I see that there is a huge increase of interest. The value of the cases, or the value of the contracts are incredibly higher than 15 years ago. So the interest around what happens is, skyrocket. But on the other side, I don't see the same, let's say, improvement as for contracts, as for players. I'm not thinking of sports players. I'm thinking of counsel. So defenses, codes and rules, and I must say that is a self-criticism, judges. So do you agree with this picture that is not generous, I know, but that's my feeling. It seems a little stuck. I don't see a great development, improvement, modernization on those fields, while the interests are higher and higher. Then the second question is, if you do agree, of course, why, based on your fantastic experience, why they go different speed? Why they have this, a kind of gap between the development of sports law, let's put in general terms, and the interest around sports?
Yes, I'm not certain I do entirely agree with your premise. I mean, certain parts, certainly I agree with. I mean, the transformation of the way in which money has flowed into sport, and concomitantly, therefore, or maybe in consequence of the interest in sport, which incidentally I think is the #1 global sport. It's obviously, Italy has a very distinguished record in football, but it's by now almost any corner of the globe one will find an interest in football. When I remember, I mean, I'm old enough to remember when there was £100 a week cap on the salary paid to professional footballers. I mean, if you think now, £100 with barely a sort of flick of an eyelash, it's multiplied sort of exponentially. So you have that, and as a result, of course, of the interest generating the money, that then generates, as you rightly say, the lawyers. Lawyers tend to follow the money. But what I'm not certain I do agree with is that there hasn't been a concomitant improvement there. I mean, I think, for example, a body such as the Court of Arbitration of Sport, they select the members, and indeed there was, and maybe still is, a football list of specialities, because after all, for a while, neither FIFA nor UEFA actually subscribed to the Court of Arbitration of Sport. They had their own internal mechanisms, as, for example, did international athletics. But I think that having specialist bodies equipped with members who are specialists because they're aware of the subject actually has led to an improvement. And I think, again, that the advocates, as I say, they may be of different, varying qualities, but nonetheless there are more of them, and the better ones tend to get the better work. So it all comes out in that way. And so, as I say, I've take the first part of your premise as being a given, But the second part, the more unhappy conclusion you draw, I'm not certain I would agree with that. And I'm quite interested to know actually whether Massimo and Luigi agree with it. I think it's become professionalized, both in terms of the persons who draft contracts, transactional lawyers, in terms of the advocates who argue cases, and in terms of the arbitrators or judges, call them what you will, who decide them.
But if I may, Stefano, I think I agree. I agree with what Stefano said with regard to domestic, to Italian situation of sports law.
Except anti-doping.
While at international level, I've seen a noticeable improvement in the advocacy, in the skills, in the effort. I mean, I remember in the 90s, when I started also as a case arbitrator, it was very rare to find briefs that could be longer than 15 pages or more than 10 documents as evidence, etc. Nowadays, the important cases, or even not so important cases, have presentations very similar to commercial arbitration. So at international level, there has been a very remarkable improvement, and also from what I can see in other countries, there has been like I've seen in Spain, I've seen in the UK, in domestic sports law situations in those countries, it has improved. In Italy, I agree with you. When I have some sports law issues in Italy, I still find the situation as you described. So to answer why is it so in Italy, I don't know, but we'll talk about it in another conference.
Well, Massimo, thank you. I actually I was wrong not mentioning that my question was based on domestic arbitration law. So I do apologize, Michael, but you answered. I mean, I'm convinced. Your answer is very well convincing because you're saying, oh, international, it is not. And so my question was whether you experience the same internationally. But thank you, Massimo, also for clarifying.
No, because I know your capacity, in what situations you act. As a judge in sports law, and I know I feel the same whenever I'm involved in Italian sports law issues. So I totally agree with you. But internationally, there has been a big improvement in the last 20 years, I would say. Anybody else from the floor? I see Mark Ovell there. Mark, why don't you tell us something about some cases with Michael, if you had some?
Well, yes. Thank you, Massimo.
That's Manchester for us.
It is Manchester. Hello from Manchester.
I guessed that.
Okay, well, I'll tell you one of my first experiences with Michael was when we were both lucky enough to go to the Rio Olympics, and my flight from Manchester to London was delayed, and I actually missed the flight from London to Brazil. And so I had to stay overnight at Heathrow, and then the next morning I got the same flight, or the next flight down to Rio, and Michael was on that flight. And I was telling him how worried I was that I'd missed a day of the ad hoc, and there were all these Russian cases coming in, and Matthew Reb was not very pleased with me. And he was very kind. He put my mind totally to rest. And at the end of it, I was thinking, well, I was very grateful I'd met Michael and he'd put me at ease. And then we walked onto the plane. And of course, Michael went left straight into first class. I said, I'll see you at the other end, boy. And when I did see him at the other end, he walks off the plane with Princess Anne and Andrew Murray, who just won Wimbledon. So there you go, how the other half live.
Yes, can I just say it was not a discrimination based on our roles within CAS. It was rather that I was also being funded by what's now World Athletics. So I had, as it were, two sources paying for me, and that got me to first class, nothing other than that. But you were absolutely right. There was Princess Anne just in front of me, and there was Andy Murray just behind me. And, yeah, very interesting.
And
any other questions? We've got about
yes.
5 minutes or so, yes. So I'm happy to stay.
Anybody else wants to ask something from Michael?
Can I just actually, anecdotally, you mentioned right at the start, Luigi, that I'm now Casey, whereas the book was QC. And it's it's pure coincidence. I was actually giving another interview about the book to this body called Law in Sport on the very afternoon that Queen Elizabeth II died. And we didn't know that she died until after I concluded the interview. And I keep on asking myself, had we known before, would we have had to cancel it or not? But that's a purely hypothetical question, but it's a sort of very, very small footnote in my personal history as to why it was. I'm now KC and the book is QC. It's not, as some people have maliciously suggested, a typographical error.
A reason to
If I didn't type it, it is true.
anybody else?
It's interesting, Michael, what you mentioned before in your book, you say that there has been a Europeanization of English procedure. This is interesting. Can you expand a bit on that?
Well, yes, I think the answer is that far more attention now is paid to written submission than to oral advocacy. Indeed, I remember, Mark, this is probably too young to remember, a time when you weren't expected to provide any kind of written submission in advance of a hearing. And indeed, in my early days, I remember once with a QC who was leading me, we produced a written submission and the judge simply refused to look at it. I mean, that's a complete change now. Not only do you have to provide written submissions, you have to provide them in advance, you have to expect your expectation not always fulfilled to the detail that it will have been read. And that's why I say there's this being what I call the Europeanization of procedure.
This is very interesting. Thank you, Michael.
Massimo, Luigi, we have a comment by Giuseppe Scott in the chat. I don't know, maybe he wants to step in
Giuseppe.
and directly.
Hello.
Giuseppe,
hello, everybody. No, first of all, let me say hello to my friends Luigi and Massimo, and also to Stefano Azzali. I made this comment because this was the first thing that Giorgio
tell us
Bernini
about
told.
I didn't read it, Giuseppe. Why don't you mention the comment? I didn't read it.
And the comment that on the subject of boxing, I remember that my mentor, Professor Giorgio Bernini, always mentioned that when he arrived in Michigan for his LLM in the 50s, in the first 50s, he faced in a boxing match a classmate who had mocked him, and that after defeating him, he gained respect of all the other classmates. So that his motto was strike first and strike hard, which in his conception should also apply to lawyers, and which, for me, at least in my experience, is not entirely wrong. So that was the first thing that he said to me, told to me when I started working for him in Bologna a long time ago. And when you were talking about boxing, this was the first impression I had, basically.
Oh, well, there we are. It is of use then, obviously, to lawyers as well as to pugilists. I've had many boxing clients, actually, when I was still as an advocate. I think 5 world champions, including Lennox Lewis and John Conte and Jim Watts. So I got to know a few of them. It's not a sport, frankly, that I enjoy very much, but there it is. You take your clients where they come to you.
Speaking about advocacy, because, you know, at the end of the day, when Giuseppe speaks about striking hard and striking first, he also speaks about advocacy. I'd like to mention, to read a two-line sentence, a three-line sentence you write in the chapter, The Art of Advocacy. You say, the object of the exercise, advocacy, is not to show the judge how clever one is, but to show the judge how clever he is. The only audience to keep in mind is the court, not the client. Would you like to expand a bit on that? I found fascinating that sentence.
Well, I think it's actually true. I mean, your job, and you're a professional, you've been instructed because you are a professional, is to do the best you can for your client. Now, many clients tend to want you to, as it were, go in hard, go in swinging, etc., etc. And that may not be the way to impress the judge. It is true that you might come out and you've lost the case and your client will blame you. Why didn't you do this, that, and the other? But it may simply be that you've taken the view that that's not going to be the best way of handling the particular judge or arbitration or panel or tribunal that you're appearing in front of. I mean, that's... That, after all, is what one's paid to do, and that's what one's trained to do. And you really, I mean, the client can't insist. You must have a discretion as to how you present the case, and you certainly can't, and this isn't an answer particularly to the point, but it's an important point to make independently, you certainly can't break, as it were, the rules by, say, concealing documents that should be disclosed, or simply abusing a witness in order to try to make your client happy that you're really attacking your opponent in a way that he regards. As I say, at the end of the day, you've got whoever's deciding the case, he or she or they are the persons that you've got to impress. That really is the name of the game. Yes. Insofar as advocacy is a game, which is up itself.
It's an art or a game, depending on how you see it.
I prefer to call it an art than a game.
Luigi.
I do not know whether there are other people who want to say anything, because from tea time in England, we are going to dinner time in Italy, and also to a match time, because there is a...
I see Ulrich connected. Ulrich, are you there?
Absolutely, and I have, I mean, the greatest fun and pleasure listening to the questions and the answers. Absolutely.
Ulrich, why don't you say something about your experience with Michael? Ulrich Haas is one of the most well-known arbitrators, not only at the CAS, also commercial arbitration professor in Switzerland, then in Germany, then in Switzerland. Ulrich, why don't you tell something about your experience with Michael?
Yes, well, one thing that always intrigued me with Michael is his ability to look at the facts of the case. I remember we had one really difficult case with an Afghan president of a federation. Really unpleasant case, because it was about abuse of female players, and of course it was all about the evidence that you had. Yeah, it's like a mosaic that you have to put together, and what always fascinates me with Michael is how he puts together the puzzle, yeah, with thousands of little pieces that really, once he looks at it, fall into place. And I think this is one of the biggest assets, and probably something that also at university people are not taught. I mean, how to deal and assess the evidence. This is the real art from my perspective. Applying the law probably is sometimes much easier. It's really looking behind the facts, and also having this experience of life, how these different pieces just fit together.
Yes, I mean, it's a very interesting comment, Ulrich. As you know, someone for whom I have the greatest respect, we enjoyed sitting with for many years. I mean, at the end of the day, it is a little bit like a jigsaw evidence. If there's a piece that simply doesn't fit, it must mean that your conclusion or your provisional conclusion is wrong, and you have to go back and look at it. And many very distinguished judges have said, certainly in my country, and I suspect in other countries, that actually sometimes the law is easier than the facts. And the facts are those which actually dictate probably most of the results in cases. I mean, Ulrich's an absolutely brilliant lawyer, and funny enough, it's a great pleasure to speak to him today, because I'm just doing one of the arbitrations I do in the field of cricket, not a sport, I know that is known very well in civilian countries, in which an issue has come up, and the Valka decision, which Ulrich chaired the panel, I was party to the decision, all about the issue about the distinction between criminal procedure and disciplinary procedure. And I think that what Ulrich there said, with the consent of his colleagues, about the difference there, the conclusions and consequences that flow from that, is really of great significance and importance. Anyhow, you're rightly or wrongly, it's being applied now in an awards time drafting.
But maybe one final anecdote here. I mean, just to show you how he's able to win the hearts of people. I remember that we were sitting in the stadium at the Olympics in Rio, and I was there with my family. And then once we left, my son, that was probably 14 years old at that age, he followed Michael and not me out of the stadium. I had so. Apparently he was much more intriguing and interesting than his family, and yeah, it took us quite some time to recuperate our son.
It's probably what Luigi said about Beijing. It was the transport people who I think got very friendly with, and maybe he appreciated there was more of a possibility of getting a car. But I have no idea. It's very charming of you to mention that.
All right. So, if there is no another intervention, Luigi, do you want to close?
Maybe no. So Massimo, Luigi, I think you can close the webinar. And of course, thanks on behalf of AIA and CAM, of course, for Michael for his intervention. It was a very interesting discussion. So
yes, but the question,
expectations were met.
The question that we were asking is why did Michael write a book? Now we can have maybe an answer from the reader's side, so which is to have an example of it is impossible to be Michael Beloff because there is only one Michael Beloff. But still you can learn from the passion that transpires from the book how to improve your profession, because this is the best point that is coming out of this book after reading it, that you need to be passionate in your activity to achieve something and this is clearly the main point behind the Michael's force.
If I may add a footnote, also it's important to have sense of humor, and it's a very witty book. I advise really to buy it and read it, because while I was reading it, I was smiling a lot, and my wife was asking me, "Is it funny?" Well, yes, it is, because you read about anecdotes, and Michael has this marvelous sense of humor, almost in each sentence of the book.
The point of name dropping, because it's obviously that you name drop when you and the Michael's temptation was to answer by quoting another indication, saying when there was a person challenged with a similar offense, he responded, That is just what the Queen Mother was saying to me the other day.
Can I just say before you close, I mean, it's been a privilege and a pleasure. I know that's a cliche, and I don't like using cliches, but I've hugely enjoyed this evening. And if by any collateral chance more people buy the book, well, I'd be grateful for that as well. I hope one way or another to keep in touch with you over the years to come.
Yes, absolutely.
Thank you so much. Thank you, Michael, and for all, you know, the passion and the pleasure of having been sitting with you for many years.
Okay, thank you to everybody. We can close here, and thank you, Michael.
Press the leave button, which is just within my technical competence. Have a pleasant evening as well. Bye.
Everybody.
Thank you.
Thank you. Bye-bye.
Bye-bye.
Bye-bye.